We urge the U.S. government to work with the South African government to reconsider the existing clauses in the draft policy, which would restrict, if not eliminate, forms of incremental innovation. Adequate and effective protection and enforcement of IP is vital to America's economy. We look forward to working with you and our trading partners to secure meaningful IP policy improvements that produce economic benefits in the U.S. and throughout the world. Thank you very much for your time today. Really appreciate it.
Thank you very much for your testimony. We do find ourselves at the 10-minute mark, so we won't have any time for questions.
Okay. Happy to do follow-up, though.
Yeah, we'll pass the questions to you in writing, and the questions will be posted at regulations.gov for everyone's benefit.
Okay.
Thank you very much.
No, thank you. Appreciate the time.
I'd like to call the next witness, Intellectual Property Owners Association. Welcome, sir. Thank you for joining us today. Please introduce yourself and spell your name.
Thank you. My name is Herbert Wamsley, H-E-R-B-E-R-T.
Microphone.
My name is Herbert Wamsley, H-E-R-B-E-R-T. Wamsley is W-A-M-S-L-E-Y. I'm the Executive Director of Intellectual Property Owners Association, or IPO. I want to thank you for the opportunity to testify today. IPO is a specialized trade association in Washington, D.C., representing more than 200 companies in all industries and fields of technology that own or are interested in IP rights. I want to highlight some key points from the 16-page letter that we submitted on February 7, and to emphasize patent and trade secret rights. I will try to avoid too much duplication with the previous witnesses. IPO members create and commercialize new products and services that drive exports and create jobs. Innovation is not without risk, and we rely on our IP rights at home and abroad to protect our investments in new technology. We've observed a growing trend in international intergovernmental bodies to focus on exceptions and limitations to IP rights, or to otherwise weaken IP rights. While such exceptions and limitations are said to be designed to increase access to technology, we believe they produce exactly the opposite effect by creating uncertainty that deters investors. We've observed attempts to weaken IP in a range of UN bodies, including the UN Framework on Climate Change and Convention and WIPO, an organization whose very mission should be to foster innovation. Similar proposals are being made in the World Health Organization and the WTO. Sometimes the proposals call explicitly for IP weakening. At other times, the proposals employ a more subtle approach of calling for the removal of barriers to technology transfer. I would like to mention some specific countries briefly: India, China, Brazil, South Africa, and Canada. India, of course, is an important market for U.S. innovators with an economy that draws heavily on global investment and trade. Several members of our association have a significant presence in India. However, India's government pursues an agenda of forced technology transfer and intellectual property weakening that is disadvantageous to American business. For example, India's national manufacturing policy calls for involuntary licensing of clean healthcare-related technologies. India has also infringed, overridden, or revoked nearly a dozen pharmaceutical patents held by foreign firms, in part because the patented products were manufactured outside the country. The stated rationale for such actions is high medicine prices. We believe, however, that expropriation of IP assets is inappropriate and deprives U.S. innovators of market opportunities. India has developed a national competition policy that provides a helpful framework for fair competition, but IP rights owners must grant third-party access to essential facilities under the competition policy. India also requires patent owners to actively work their inventions on a commercial basis within India, as we understand it. Failure to do so can subject the patent to compulsory licensing. Apparently, to encourage more requests for compulsory licenses, the Ministry of Commerce has recently published the working status of Indian patents online. Despite recognizing the link between trade secret protection and investor confidence through its national IPR strategy, no meaningful trade secret protection regime exists in India, and there's been no public move to establish one. At the WTO, India has insisted that IP rights are unrelated to innovation. At WIPO, India collaborates with Brazil to provide meaningful discussion of IP best practices. Now moving on to China, while much has been done to improve IP rights in China in recent years, achievement of an open and fair commercial landscape will require additional work. Technology developers may find themselves at a significant disadvantage through China's national standards, which are advanced through an invitation-only process, often to the exclusion of foreigners. IPO members must cope with laws that impose greater risks and liabilities on foreign technology licensors compared to domestic innovators. Moreover, a recent trademark law change may expose American brand owners to risks caused by bad faith registrants. IPO members face hurdles in expanding R&D operations in China. U.S. innovators must share their know-how with others to build new solutions, risking exposure of essential trade secrets. While trade secret laws in China exist, recovery of damages is extremely difficult. Companies must also reveal their trade secrets to comply with regulations with no assurance that the know-how will remain confidential. China is complex. Employers must face the onerous requirements of service invention regulations governing employee inventor rights and navigate the uncertainties created by the unexamined utility model rights. Briefly on Brazil, Brazil's position on IP rights has improved domestically and globally over the past few years. Nonetheless, there are areas of real concern. For example, both IIPA, Brazil's patent office, and Visa, the National Health and Surveillance Agency, examined the same pharmaceutical patent applications with different standards. This dual system compounds the patent backlog in Brazil, where patent examination takes 8 to 9 years. The Patent Office regularly interferes with technology transfer agreements, which can result in the loss of U.S. trade secrets. Like Brazil, South Africa is also considering its approach to updating intellectual property laws. Last year, South Africa published the draft national policy on intellectual property. IPO welcomes many of the perspectives the policy sets forth, but we are troubled by the suggestion that IPR protections must be limited in order for the country to develop and thrive. In Canada, innovators in the pharmaceutical industry face unique and heightened standards of patentability. Patent applications must demonstrate or predict the commercial promise of an invention upon the filing of the application. Canadian courts have rejected patents for their lack of utility when Health Canada has found the same inventions to be safe and effective. In conclusion, we believe key elements of intellectual property systems can be strengthened through the TPP and the TTIP. In particular, we appreciate the efforts the United States has made to include trade secrets on those agendas. We thank the subcommittee for its efforts to preserve the tools that will sustain and grow America's economy. I'd be pleased to try to answer any questions now or to make a submission for the record. Thank you.
Thank you very much for your testimony. We're at about the 9-minute mark, so we have time for one quick question.
Thank you for your testimony. According to a 2013 U.S.-China Business Council survey, 40% of respondents stated that trade secret misappropriation was their top area of IP concern. Is that also true for your members? And is trade secret theft your members' most significant IP challenge in China?
It's certainly one of the most significant challenges in China. We also have concerns about the growing backlog of patent applications, the uncertainty over the utility models, but trade secrets would rank near the top. As I indicated in my statement, we see trade secrets as an area for concentration in improving trade-related IP in a number of countries. Indeed, even in the United States, which has perhaps the world's best trade secret protection, our association this year will be supporting in Congress the creation of a federal civil cause of action for trade secret misappropriation.
Thank you very much, and we will follow up with some additional questions post-hearing. Thank you for joining us today. I'd like to call the next witness, the International Intellectual Property Alliance.
Michael Schlesinger, S-C-H-L-E-S-I-N-G-E-R. Good afternoon. I'm pleased to appear before you on behalf of the IIPA, a coalition of 7 copyright-based associations representing over 3,200 companies in the software, motion picture, recorded music, video game, and book and journal publishing industries. In our 26th Special 301 submission, we document online and hard goods copyright infringement and market access barriers in over 46 markets. The Special 301 program remains a cornerstone of U.S. IP and trade policy to establish objectives for the year and to protect our nation's creative industries, boost U.S. exports, create good high-wage jobs here at home, and contribute to the overall health and competitiveness of the U.S. economy. Our latest report confirms that the core copyright industries contribute 6.5% of U.S. GDP and roughly 5.4 million high-wage jobs. Yet massive costs are imposed by overseas infringement and market access barriers to U.S. copyright products and services. Legitimate businesses face unfair competition from those who infringe as a high-profit, low-risk enterprise and who are unencumbered by costs associated with producing or obtaining rights in copyright materials. Piracy and counterfeiting cause significant harm, as recognized by recent United Nations and Interpol initiatives, as well as damage existing legitimate distribution channels and impede the evolution of new ones. Thus, it is essential to the continued growth and future competitiveness of the U.S. that our trading partners provide high levels of copyright protection, more effective policies and tools to enforce copyright, and freer, more open markets. We urge the administration to use Special 301 to encourage the countries identified in our submission to take the necessary actions to bring real commercial gains to the U.S. through strengthened copyright and enforcement worldwide. I'd like to say a word about some cross-cutting initiatives and challenges to the copyright industries. First, internet and mobile infringement unfortunately compromise opportunities to build legitimate businesses in the online and mobile world. Governments must address both supply and demand, including education, as well as enforcement and incentives for service providers to help curb both hosted and non-hosted infringements. The role of advertisers, payment processors, and search engines should also be more carefully scrutinized so that infringers are not given an upper hand and so that these services are not knowingly benefiting from or contributing to infringement. Second, severe damage is caused by enterprises and even governments that engage in end-user infringement of software, published materials, and other copyrights. Adequate laws are needed, including statutory damages and, in appropriate cases, criminal penalties. Third, retail infringement continues to cause mounting losses, including hard disk loading of software onto computers at the point of sale, mobile device infringements involving the loading of infringing material or illegal apps onto smartphones, tablets, or other devices, the trafficking in media boxes facilitating massive infringement, and high-quality counterfeits manufactured mainly in China and exported to the world. Fourth, while technological protection measures have enabled more access to copyright at more affordable prices than ever before, those who build their business models around circumvention of TPMs have exacerbated infringement and undermined the development and deployment of legal services. Other industry-specific problems include illegal camcording of movies from theater screens, infringement of books and journals, and pay TV piracy and signal theft. For example, there were 819 total detections of illegal camcordings of major U.S. motion pictures in 2013. These can trigger mass distribution of millions of internet downloads, so a multifaceted approach is needed, including education, cooperation with cinema owners, and adoption of adequate legal measures and enforcement. Large-scale unauthorized photocopying of books, principally on and around university campuses, and sophisticated counterfeit printing cause publishers significant harm and must be addressed. The unauthorized broadcast, cablecast, satellite delivery, or retransmission of broadcasts require a regulatory and enforcement response focused on the trafficking in signal theft devices or technologies and unauthorized decryption and redistribution activities. Two additional challenges noted in our submission include the need for proper implementation of IPR provisions in trade agreements and the need to address market access barriers. Multilateral, regional, and bilateral trade agreements have proven to be of great value to the U.S. economy, featuring enforceable obligations to modernize copyright laws, improve enforcement procedures, and open markets, and providing the win-win impetus for the development of our trading partners' domestic copyright industries. The negotiations towards a Trans-Pacific Partnership FTA present an opportunity to expand the benefits of existing FTAs to a broader range of markets around the Pacific Rim, promising contributions to U.S. job growth and increased exports in line with the administration's goals. Market access barriers, investment barriers, and discriminatory treatment, on the other hand, continue to make it impossible for U.S. businesses to compete fairly in many foreign markets, or to crack down on copyright infringement, which fills the void. In sum, we urge the U.S. government to use all its tools to uphold U.S. trade laws to meet the challenges presented in the IIPA submission. We thank all those in the U.S. government who work steadfastly throughout the year to ensure that our trading partners respect U.S. intellectual property and open their markets to our products and services. With that, I'd like to be pleased to answer any questions that you have, and I just want to recognize the significance of the participation of many governments in this process. We're reviewing their submissions, as I'm sure you are, and their testimony today, and we look forward to progress in the year to come through continued bilateral engagement. Thank you.
Thank you for that broad-ranging testimony. And thank you for leaving 3 minutes and 25 seconds for questions. And you gave me the perfect segue there, and this might be a little bit unfair, but I'm going to put you on the spot. IIPA, I think, has nominated, in quotes, more of the governments that appeared here today than any other organization. So specifically in your 2014 submission, you provided information on Ukraine, Bulgaria, Italy, and the Philippines. And I'd like to give you a chance to just do a tour of the horizon for us on those governments, if you would.
Sure. You said Ukraine, Bulgaria, Italy, and the Philippines. Sure. Well, on Ukraine, we absolutely appreciate the appearance and the testimony of the government of Ukraine this morning. Our position is that the government has not yet corrected any of the 3 identified PFC investigation issues to date. On February 28th, that PFC investigation officially ends. So recognizing the political changes that are afoot in Ukraine, and as mentioned in their testimony this morning, we believe it's appropriate that as the changes sort themselves out, the U.S. government should once again turn its attention to those 3 PFC issues. I'm happy to say further word on those. With respect to Bulgaria, what I would say is in our submission, you'll see that the cybercrime unit has been a bright spot in an otherwise difficult situation. And I think that it is very important to continue to monitor enforcement efforts in Bulgaria, which unfortunately stalled in 2013. So that would be the elevator pitch or the talking point on Bulgaria. In Italy, I think that we recognize as an alliance that the AGCOM is a major development. We also recognize the positive developments in terms of the fiscal police activity in 2013. We believe that it's very important to follow up with monitoring the implementation to ensure fluency in continued enforcement, including obviously very importantly in the internet environment, where we highlight Italy's rise, unfortunately, in terms of illegal activities in that space. Finally, on the Philippines, which I didn't have to write here because I've been working on Philippines for many, many years. As you know, for a couple years now, we have recommended that the Philippines come off the watch list officially. We do still continue to believe that it's important to monitor that out-of-cycle review is an appropriate way to measure the progress in the Philippines. This is taking note of all of the accomplishments that they've taken to date, including the passage of an optical disc bill, the implementation or the beginning of implementation of Supreme Court rules on IPR, which should hopefully resolve some of the irritants that we've experienced in the courts in the past, such as the search warrant quashal issue. And just in recognition of really the IIPA, as they said this morning, that their targeted enforcement and their continued willingness to work with us on every new challenge that's facing itself, and I think they mentioned the internet this morning, and we were heartened by that, and also TPMs. So we think that the situation in the Philippines is ready for them to graduate to really a more mature place on the Special 301 list through a continuing review process.
Okay, thank you. We find ourselves at the 10-minute mark, so I'm going to apologize to my colleagues for preempting your questions with my own, but we will go ahead and forward those to you after the hearing. We would appreciate response within the next 2 weeks, please.
Thank you very much.
Thank you. I'd like to invite the